Hi, Lawrence LeBrocq, Managing Partner of Garces, Grabler, and LeBrocq, your injury law firm. Here today on Victim to Victory. I brought in today Ralph Cretella, one of our top associates at the firm. Ralph has graduated from Rutgers and Rutgers Law. He graduated summa cum laude, and he's one of the nation's top 100 trial lawyers, designated by the National Trial Lawyers of America. So Ralph, welcome to the program.
Pleasure to be here.
It's good to have you here. We're going to talk a little bit today about slip and falls, also the workers' compensation bar, and when you're injured on the job, sometimes you can be precluded from suing your employer. We're going to get into that. We're going to peel back the onion and the curtain here, just so people understand what some of the challenges are in a slip and fall case. So with a slip and fall case, you have to prove notice. What's the difference between actual and constructive notice?
So the idea of notice, you think of notice as, well, did the other party, the party that you're attempting to hold liable, were they aware that there was a negligent condition on their property? So actual notice is exactly that the party actually knew that there was a negligent or deficient condition within their property or premises, and they did nothing to correct it. Actual notice it can be proven a number of different ways. One is, did the person that you're trying to hold liable, did they create the condition? That's really the first element and the most important element, because once you can prove that a property owner knew or created the condition, they'll be able to be held liable.
And then what is constructive notice?
Constructive notice is a little bit more trickier to prove, because you kind of have to put yourself in the place of the other party and say, well, should the liable party have known about the condition? So constructive notice is basically, maybe they didn't necessarily create the condition, but they did nothing to remedy or rectify the condition. And if they had done a reasonable inspection to identify the condition, they would have been able to correct it.
So an actual notice, one example of an actual notice is if you're shopping in a grocery store and they know that they have a refrigerator that's broken and leaking, and that leakage goes onto the floor and somebody slips in that.
That's exactly right. Actual notice is let's say the supermarket or whatever store you're shopping at is already aware that this defective item is defective, and in creating a negligent condition, they're aware of it, they know of it. Actual notice.
So that's one of the catches, is when people get injured in a slip and fall in a department store, grocery store, or some other premises, that the owner of that premises has to have knowledge or notice that that condition exists. Because you could have somebody in a grocery store just walking down with their kid's sippy cup and spill it on the floor, and the person behind them trips on that spill. They would not have time, they wouldn't know about it, and they wouldn't have constructive notice because the defect wasn't there long enough.
That's a perfect example. I've litigated cases against big-time supermarkets with very similar fact patterns, where we had a customer who was just browsing an aisle, and she was caused to slip and fall on some soap or detergent that had been caused to exist on the floor. So when that happens, at that time, the injured party, our client, has no idea what caused them to fall. They just know they slipped and fell and there's soap all over the ground. But it's our job as the attorneys to figure out how that soap, how that detergent came to exist, who created the deficient condition, and why wasn't it cleaned up. And in a case like that, we were able to look at security footage. And a big challenge in that case was that minutes and seconds prior to our client slipping and falling, another customer had dropped a bottle of soap on the ground. And within about 2 minutes, the soap had spread, created this condition which kind of blended in with the floor, which had blue patches, and our client went down. So, the supermarket obviously highly litigated that case on the basis that they would be able to, get out by way of a motion, asserting that they didn't have constructive notice and they didn't have actual notice because they didn't create the condition. But that was a case that I was able to successfully litigate through way of motion practice for a favorable result for our client.
Which is great, because that's one of the things. They have to have time to clean up any spills in that.
They do, and there's case law on it. I believe it's somewhere around like a 5-minute mark. So anything that's like under 5 minutes, it's not reasonable to expect that a property owner or a supermarket or something like that would be able to remedy that situation or that deficiency. But anything over that, they could, because when you own a very busy, whether it's a shopping plaza, supermarket, whatever it is, you have the duty to conduct routine and regular inspections to make sure that the patrons of your store can shop, in a harmless and peaceful manner without having the risk of being injured.
And the only way to discover that is through what's called the deposition, which is a question and answer period under oath. And who would you depose in those type of cases with a slip and fall on premises? Let's just say, let's stick with the store.
Sure, like in that case that we were just talking about, I believe I deposed the store manager, I deposed associates who responded to the immediate situation, we deposed fact witnesses. The things that we needed in a case like that is we needed to talk about policies and procedures within the store, because it's very important. A lot of supermarkets, a lot of stores are self-service now. You don't have, employees doing your shopping for you when you go to a grocery store or supermarket. So, patrons are self-serving themselves. And when that happens, it's expected that things fall to the ground, things drop, conditions can be created. So you have to depose and you have to get information from anyone who would be knowledgeable as to the policies and the procedures as to that particular supermarket, but as well as the policies and procedures across the industry.
Right. And then you have to hire experts, and that's where it helps to have a good deep war chest with a lot of money so you can pay for these experts and do all the necessary depositions, because they are very expensive.
And that's what happened. We were going up against a super billion-trillion-dollar corporation who has all the money in the world. We hired liability experts. We had an expert who specialized in shelf stocking. And this individual, our expert, came, he took measurements of all the shelving. He talked about, standards within the industry, about, how high a stock should be, shelved, all different things that you and I would never know about, but only someone who's very involved and very knowledgeable in the industry.
Now, I'm going to just go over to the workers' comp bar so people understand that in New Jersey, you cannot sue your employer in negligence. However, you can sue them in workers' comp. And I'd love to give this one example where I had a client one time working on the job, beautiful summer day, was working with a table saw. A beautiful woman walked by, and he was looking at the beautiful woman and not what he was doing, and cut off a finger. Now, he was at fault, but he could still sue in workers' compensation because you don't have to prove negligence. Now, in order to sue an employer, there's a lay low standard. So let's discuss that a little bit. If you want to sue your employer, what is that standard?
Right, so exactly how you laid out. In general, if you're injured while on the job, as long as your employer carries workers' compensation insurance, you can proceed with a workers' compensation claim. Now, if you're injured on the job and it's due to the negligence of another party that's not your employer, you could also sue that defendant or that potential party in a normal civil litigation case.
So just for an example there, if you're a painter and you're a subcontractor working on the job, who would you then file suit against that's not your employer? Obviously, your subcontractor, you can't sue for negligence, but who could you sue in a situation like that?
Let's say you're working at a home, potentially the residential homeowner, if there's an defective condition that the homeowner caused. Let's say you're a painter on the ladder and the ladder snaps. Maybe there was a product defect with the ladder. You would be able to sue the manufacturer of the ladder. But to get back to the point where you were asking about how can you sue your employer in addition to pursuing a workers' compensation claim, and that's something that we call a Laidlaw case. And Laidlaw is a legal case. It's a case that happened here in New Jersey, where a plaintiff was injured, but it basically has to be that the negligence of the defendant is so egregious that essentially the defendant knew or should have known that would have created a harm to the prospective party using it.
There has to be a substantial likelihood of harm as a result from the activity that the employer is asking you to do. And we've overcome some of those things. I've had a situation where a person had an explosion because they were working with acetone and the employer forgot to turn out the pilot lights and the building exploded. So that's one where they knew there was a substantial chance or a substantial likelihood of injury if they don't turn the pilot lights off because they know it's a combustible material.
Exactly. The famous case that they talk about in Laidlaw is, let's say you're using a handsaw, right? And the handsaw has a safety guard on it. And the safety guard makes you work a little bit slower, but it protects your hand so that, if an accident were to happen or something like that, you'd be safe. Let's say the employer says, you're working too slow, we're going to remove that safety guard from all of our buzzsaws within the company. This way you can work faster. That's that deliberate act that would pierce a substantial threshold laid out in the Laidlaw case.
And it's surprising how often employers will disregard safety for speed, efficiency, and money.
More money.
It's incredible. Now you've had, and I was actually sat in with you on some of the mediations here. You actually just had a huge $2.6 million case on a workers' compensation and a third-party case. And just simply for our viewers, a third-party case is any other defendant other than your employer. So that would be a third-party case with a workers' compensation case. So let's talk a little bit about that case, and I know you're familiar with the one I'm referring to. We have a non-disclosure agreement, so we can't say the names of the defendant, we can't say the names of the plaintiff, and we can't give too much detail regarding this case, but we're going to set some parameters.
That's exactly right. We had an individual who was in the scope of his employment. He would drive, heavy-duty trucks, gas tankers across the country. This was a high-earning individual, worked very hard. One of his jobs and duties was when he would go to the yard to pick up the tanker, he would be responsible for making sure the tanker was properly cleaned. So this particular day, he climbs up to the top of the tanker to inspect it, notices that there was some improper wash done, and he slips and falls about 12 to 15 feet off a tanker, lands on his head, and sustains very serious, disabling, permanent injuries.
And it's very difficult in this case to overcome the workers' compensation bar because the truck was owned by the employer, the lot was owned by the employer, but you found a way to find a third party to go after in this case.
We did in that situation because we knew that we wouldn't be able to proceed against the employer. In fact, the employer had participated in motion practice preventing us from doing that successfully. So we were able to find a third party to hold in negligence and liability, and we were successfully able to do so.
Right. And in this case, couldn't go after the employer because there was nothing they did that would cause a substantial risk or certainty of harm. So there was no substantial certainty of harm in this case. It was just a negligent case, and it was really just negligence on the third party who didn't clean the truck properly, and this person slipped and fell. But you did a great job through all the motion work and years of hard work on this case, because this case was actually dismissed from the court, and you were able, through a great brief that was done and some affidavits, to reopen that case.
We were. where it was a great team effort by the law firm. But that shows the persistence and ability of a firm that that we have a size like that. And just because the case was dismissed doesn't mean it couldn't be reinstated. And it is pretty rare for something like that to happen. But these big companies and these big corporations, they try to be paper bullies. And unfortunately, a lot of the smaller law firms or the firms that are not familiar with litigation are ill-equipped to handle these types of motions and these types of litigation practices. And that's why, when you have a case where you have very serious, life-altering injuries, you have to go and pick with a firm that, can represent you the best.
Right, and let's just talk a little bit about that. Why is GGL such a strong litigation firm? What are some of the core values of the firm that we try so many cases?
Sure. When it comes to trying our cases, one of our biggest core values is maximize client recovery, right? One question: when an injured party comes into your office and their life has been totally changed and uprooted, and they can't go to work anymore, they can't provide for their family anymore, they want to know, how am I going to be compensated for this loss? So as injury attorneys, litigation trial attorneys, it is our job to maximize our client's recovery on every single case, whether it's life-altering injuries, whether it's injuries that have had a minor effect on someone. Regardless, we treat every case the same.
So if somebody is injured in a slip and fall or a trip and fall, because there is a difference, you could slip on ice, you could trip over a raised sidewalk, what are some of the things they should do immediately?
The first thing you should do is ask for medical assistance. That is probably the most important thing. If you're laying on the ground, you just tripped on a black ice in a parking lot, or you tripped in a supermarket off a puddle of water, tell them you want medical assistance. The people who are coming to help you are not doctors, they're not physicians, they don't know what they're doing. Unless you yourself are a doctor or some type of medical personnel, you don't know what type of injuries you may be sustained. Who knows, maybe you hit your head. Ask for medical assistance. Get checked out, number one. Number two, fill out an incident report. Information goes missing. Oftentimes, I hear a client come in, I tripped and fell, I slipped and fell. Oh, did you do an incident report? Oh, no, the store said I didn't have to do that. Of course the store doesn't want you to do that, because then there's no record of the incident happening. Fill out an incident report. 3, take pictures if you can. If you're not able to, ask someone to take pictures for you. Conditions like ice, snow, water, they're transient conditions. They're not always there. They disappear over time. You have to have proof, right? If you're going to bring a lawsuit for injuries, you, as the person bringing the claim, have the burden of proof. So a defendant can come in and say, oh, well, we came in and we shoveled the driveway. I don't know why they slipped. We shoveled it. If you don't have a picture showing snow all over the driveway, very, very difficult case to litigate. And that actually happened in a case that I handled once.
Right. It's also, we just had one come into the office recently where a person tripped over some ripped up old carpet, significant injuries, and when the person went to the hospital, they changed the carpet.
Happens all the time.
And when they got back to they were renting the premises, when they got back, they had new carpet in there and couldn't take any pictures. And unfortunately, this person was so severely injured that they had to go to the hospital in the emergency room, so there wasn't an opportunity for them to take any photographs. And that's also how important it is to contact a law firm immediately.
Immediately. The second you're discharged from any emergency care, I would contact a law firm immediately.
Because as you said, evidence will disappear, and what a good law firm will do is they'll send what's called a spoliation letter, and that prevents the defendant from destroying any of the evidence, changing that carpet, doing that so quickly. So that's something that you really want to do when you hire an attorney. And so a lot of people, they feel like they don't want to sue, but when they find out that nobody's paying their medical bills, then they get upset and they call a lawyer. And sometimes that's a little too late.
It is.
Because they can then, a lot of evidence could disappear over time. Let's talk a little bit about more about some of the trip and fall cases or slip and fall cases that you've had in your career and some of the challenges involved in those.
Sure. Generally, with premises, trip and fall, slip and fall cases, issues that commonly and that we have to deal with as attorneys are, number one, the most important thing and the hardest thing is proving that a party was negligent. I remember a few years back I was handling a case where a woman slipped and fell on snow while she was walking into her job. And the parties were adamant that they cleaned, they did a good job cleaning, there were no issues. Okay, the snow removal company came in. We came in, here's our logs, look at all the work we did. This case went on for years and years and years, and they refused to make any offers. I kept digging because it was my understanding that there was video surveillance that the client's employer was potentially in possession of. And I finally got a copy of the video. This is years later. It totally blindsided the other side. And it showed the parking lot, and this place was a disaster. It looked like a snowplow hadn't even come through. And the second I amended and sent that video to them, the case resolved.
Right. I had a similar case years ago, slip and fall on ice. A woman was going to visit her grandmother at an apartment complex. She got out of her car and fell immediately. It was just a sheet of ice. Didn't get hurt. She walked into the rental office and said, "You better take care of this because I'm young and healthy. If one of these older people fall, they're probably going to break a hip." She went, visited her grandmother, went walking back, fell again, and got significantly injured. And they were arguing that there was blizzard conditions, we couldn't clean it. But because we had photographs from the apartment that showed the parking lot of a strip mall across the street that looked like a spring day. There was no snow or ice in that parking lot. It was cleaned so well, but yet it looked like it looked like tundra in this particular parking lot. So it's very important to get your investigators out there quickly.
That's a challenge that a lot of premises liability cases have. Evidence, preserving evidence.
Now, so you understand, Ralph Cretella not only is one of the top 100 trial lawyers, he also has his certification as a trial lawyer pending here in New Jersey. And that's a significant accomplishment. What does it take to become a certified trial lawyer? And people probably don't understand, only just over 1% of all lawyers in New Jersey are certified lawyers, and there's different certifications. So very few are certified as civil trial lawyers. And what's that process take?
It's actually a very, very detailed and lengthy process. I think that's what probably even deters the attorneys who may even be eligible to apply. It deters them from even trying to apply for certification just because of how lengthy the process is. But basically, the Supreme Court of New Jersey, the highest authority in the law of New Jersey, can certify attorneys who meet specific requirements as to their level of practice within civil law, right? Personal injury attorneys practice civil law. So a part of the certification, the Supreme Court wants to know every single case that you have taken to a jury verdict trial. They want to not only know every case, they want to know the outcome of the case, and they also want not interviews, but they want statements from opposing counsel that you've tried those cases against. They have to write an affidavit or recommendation, as well as the judges that you tried those cases in front of. And that's just step one. Step one is you have to meet the eligibility requirements through a number of trial days, total trial days.
And so to become certified, not only do you have to try a certain number of cases, but you have to have a recommendation, not only from the judges, but from your adversaries that you are competent at trying cases. And then what's the next step?
Then after that, the Supreme Court of New Jersey wants to know 20 significant cases that you handled per year for the last 3 years. They want the docket number, the judge it was before, your opposing counsel, and the result of the case.
Right. And then you have to take a test.
And then the last part is you have to take a written examination. So, like in middle school, they used to give you the blue books, or in law school, they gave us the blue books. And the examination consisted of watching on video fact patterns that were live courtroom scenarios. The test was about 6 hours. It was a whole day. A scenario would be played. The video would then be paused, and then the question would be posed. If you were this lawyer, what would you do? If you're the opposing lawyer, how do you respond? And then if you're the judge, what is your decision?
Right. And it's the same test that I took over 20 years ago when I became certified. What's amazing about that test, that was probably the most practical legal test I've ever taken in my life. In law school, it's a lot of theory, but that's very practical because it's like live court scenarios.
It was like being a lawyer.
Yes. And so it's not something you can fake.
No, in law school, there were probably 2 or 3 courses that actually taught you how to be a lawyer.
So what do you enjoy about litigation?
I am a fierce competitor. I think you know that. I don't take no easily. When an insurance adjuster or insurance company or defense lawyer calls me and says, well, there's all these issues with your case. We're going to offer you X amount. And I go, that's really awesome and that's fantastic, but our case is worth triple X amount. And you get to prove why you're right. And there's not a lot of professions where, you have that ability to convince people as to why your position is right. I laugh all the time. Clients come into my office or friends and family, and they always say, oh, I was going to be a lawyer. I was going to go to law school, but it takes a certain special kind of person to actually go through it.
Well, yeah, it's 4 years of college, 3 years of law school, and then a lot of time to practice your trade to become very good at it.
You have to like to argue,
Yeah.
but you have to like to be right.
Yes, that's important. As a certified trial lawyer myself, I think you need that fierce competitiveness. And I know you were a hockey player and an athlete growing up. I went to college on athletic scholarship, and I think that the sports mentality, that competition, really helps you, because if you don't try cases, it's like just going to practice all the time and never getting to play the game, where you can see that competition and how well you've prepared and how good you are.
Yeah, absolutely. And, coming from an athletic background and playing sports, you have to know how to lose also, because you don't know what it's truly like to win until you've lost.
Right.
No one wins 100% of the time.
Yes, and any lawyer who says they've won all of their cases has probably tried one, or they're probably lying. Because if you try enough cases, you're going to lose, because the insurance companies normally want you to try the unwinnable cases, the ones that they know that they have a great chance of winning. Their actuaries run it through the computer system, and you don't have a chance of really winning, and they'll offer you full settlement value on your strongest cases. So it makes it even more challenging. But you've been very successful throughout your career, and what do you attribute that to?
I think it's very important to prepare. Preparation is everything. Whether it's sports, whether it's doctors, these professionals don't just wing it or just give it, the old college try. These are professionals, and myself, where I want to be the most prepared person when I step into a courtroom. I think that if you're the most prepared person, you are the most probable person to be victorious in a lawsuit or a case like that.
I tell everybody that trying cases back when there was paper, I would read every piece of paper in a file. Now you're talking about red wells upon red wells, but you want to know everything in a file. And it's that preparation. It's what people don't see. It's all those hours and days of preparation when you're alone in an office, just going over document after document and prepping your cross-examinations. That's where you win these cases. It's not, it helps to be good on your feet at a trial and presenting a case to a jury, but you wouldn't be able to do that if you weren't prepared.
That's exactly true. I mean, only a trial lawyer knows what it feels like to be on trial. When I'm on trial, I sleep very little. I eat very little. You're spending all of your time preparing, practicing your arguments. My family knows when I'm on trial, they don't see me probably for 2 weeks because of the hours that I'm in the office, the hours that I'm leaving to go to the courthouse. That just comes with the job.
Right. And that's something that a lot of people don't want to do. So there's a lot of law firms out there that just settle cases. They don't try cases. But at GGL, we're real trial lawyers, and we have a lot of certified trial lawyers at the firm. You're being one of them, one of the multi-million-dollar lawyers at the firm. And I know last year alone, you did over $10 million in verdicts and settlements for your clients, just you as a member of the firm, which is incredible. So it was great having you on the show.
Thanks for having me.
And we appreciate it. And I'll see you back at the office.
Look forward to it.